There was a time in American history where student loans could be discharged in bankruptcy, just like credit card debt or other kinds of debt. Then Congress became concerned that lenders would be unwilling to lend students money to go to college, to go to graduate school, because if people just willy-nilly get rid of them in bankruptcy, well, then that takes away some of the protection that the lender expected. So in order to not discourage lenders from making money, they changed the terms so that you had to have made the payments for 5 years, and then that was bumped up to 7. And then in 2005, there was the Bankruptcy Abuse Prevention and Consumer Protection Act that was enacted that took student loans out of the discharge category with one carve-out, and that is the way it's worded is if it would be an undue hardship on the debtor, the debtor's dependents to have to repay the loan. Now, that doesn't sound like such a big deal. Undue hardship, well, I'm having a tough time. I shouldn't have to pay my student loans. Well, courts were not quite so glib about that. And the test that was established was something called the Bruner test, based on a New York case in Ray Bruner. And it had 3 prongs. The first prong is you cannot make payments on this loan and have even a modicum of reasonable life. You simply can't afford to put food on the table, in essence. That situation must have persisted throughout the repayment period, and you've already made a good faith attempt at repaying the debt. Now, somebody that is going to be a good candidate for that kind of discharge of student debt is going to have to mount a lawsuit in the bankruptcy court, because the lender isn't just going to say, oh, okay, looks like it's undue hardship. That kind of a lawsuit is called an adversary proceeding. And adversary proceedings tend to be expensive because they're complicated. The person who'd be a good candidate for this kind of a discharge is probably in a Chapter 7 and doesn't have the resources to pay an attorney to do this. So a lot of the cases were involved pro se debtors who went up against the sophisticated attorneys at the student loan lending companies, and they lost. And so the case law tended not to be favorable to borrowers on this. There are some good cases, but typically it's the situation where the person's been badly injured in a car crash, let's say, and is never going to work again. Well, over time, the inflation rate on tuition has been very high, much higher than the inflation rate on really anything else, including medical expenses, because universities had behind them the federal government that guaranteed the student loans. So it was a win-win, and there seemed to be an inelastic demand there. They could keep raising tuition, and people still wanted to go to the universities because it was viewed as a ticket to better jobs and better income. Well, that being the case, people have incurred a great deal of student debt. And the great jobs they're getting, they do pay more than if you were just to have, say, a high school diploma, but they don't pay enough to really take care of the student debt. And I've had people come to see me who have $400,000 or $500,000 worth of student debt, and that's really the case. Hundreds of thousands of dollars worth of student debt. And yeah, they're making a nice income. Maybe I remember a woman who's a principal of a school. She had $460,000 worth of student debt. She's making $13,000 a month gross. Sounds like great money, but she was not able to service that debt. It was just too much. Well, bankruptcy wasn't going to afford her an out. And there's been a hue and cry throughout the country about this gargantuan student debt. Occasionally in Congress, something is tossed out making student debt dischargeable. There's been a push to get the president just to wipe out all student debt. Whether the president has that authority or not is a very important question that has to be addressed. I don't see that the president does have that kind of authority, but at least that's something that I'm sure you've seen in the news. Well, just recently, a bill has wended its way through Congress, and it looks like it may well become law. And what this bill says is, well, I don't know what the finished product is going to say, but in essence, it says, if you have made payments on your student debt for at least 10 years, then the remaining balance can be discharged in a bankruptcy case. So if this becomes law, then there are large numbers of people who have made payments on their loans for 10 years who could greatly benefit from doing a bankruptcy. I want to hasten to add, at present, it's not law yet. But unlike some of the other things that have been floated around, this looks like it may well become law. So if you've made payments on your student loan for at least 10 years and you're eligible to do a bankruptcy, not everybody is, and of course it depends on what chapter, then you might want to consider doing a bankruptcy to discharge that remaining student debt. So there is a series of ifs here. If it becomes law, if you've made payments for 10 years, if you qualify for that particular type of bankruptcy that you're going to pursue, and there are issues on whether or not you do, you'd have to do the analysis to be sure, then bankruptcy may be a very useful way to get rid of that remaining student debt.